Stop scrolling. Seriously. If you are close to retirement, already retired, or you have a pension, a 401k, or any kind of retirement account at all, you need to hear what I'm about to tell you right now. Because something happened at the Supreme Court level that most people have absolutely no idea about. And I'm not talking about some small procedural thing buried in legal language. I'm talking about a ruling that has the potential to change the way millions of Americans plan for retirement, protect their savings, and receive the benefits they worked their entire lives to earn. Most people won't find out about this until it directly hits their account or their monthly check. So stay with me, because I'm going to break this down in plain English. No legal jargon, no confusion, just the facts you need to know right now. Let me give you a little background first, because this part matters. For decades, the way retirement law worked in this country was relatively stable. You had your Social Security, you had your employer pension if you were lucky enough to have one, you had your 401k or IRA, and you had what's called ERISA, the Employee Retirement Income Security Act, which was essentially the federal law that protected your retirement benefits. ERISA set the rules. It told employers what they could and couldn't do with your retirement money. It gave you legal protections if something went wrong. And for the most part, workers trusted it. They built their entire futures around it. Now, here's what a lot of people don't realize. There's also been a long-running legal principle, something called the Chevron Doctrine, that has quietly governed how all of this actually worked in practice. And if you've never heard of Chevron, that's okay. Most people haven't, but here's why it matters to your retirement. The Chevron Doctrine basically said this: when federal law is ambiguous, meaning Congress wrote a law but didn't spell out every single detail, federal agencies like the Department of Labor, the IRS, or the Social Security Administration could step in and interpret what that law means. They could fill in the gaps. They had what lawyers call deference. Translation: the experts in those agencies got to make the calls. Stay with me, because this is where it gets really important for your wallet. In June of 2024, the Supreme Court issued a landmark ruling. And I want to be very clear when I say landmark, I mean seismic. In a 6-3 decision in a case called Loper-Bright Enterprises versus Raimondo, the Supreme Court overturned the Chevron Doctrine entirely. Gone. Finished. After 40 years, the court said that federal agencies no longer get automatic deference when it comes to interpreting ambiguous laws. That power now shifts to the courts themselves. The judges, not the Department of Labor, not the IRS, not the Social Security Administration, get to decide what the law means. And this is where things moved fast. The downstream effects of that ruling started rippling through retirement law almost immediately. Because so much of how your retirement benefits are calculated, protected, and enforced was built on agency interpretations that were shielded by Chevron. Once that shield came down, the entire legal landscape opened up to challenge. Let's take a step back for a second and talk about why this hits retirement specifically so hard. Think about your 401k. The rules around how your employer has to manage that money, what fees they're allowed to charge, what investment options they have to offer you. A huge chunk of that was not spelled out word for word in federal law. It was interpreted by the Department of Labor over the years. Guidance documents, regulatory rules, agency interpretations, all of it was protected under Chevron. Once that protection disappears, every single one of those interpretations becomes challengeable in court. Here's a real example, so this makes sense. There's something called the fiduciary rule. This is the rule that says the people managing your retirement money, your financial advisors, your plan administrators, have to act in your best interest. Not their best interest, yours. Under the old system, the Department of Labor had broad authority to define what best interest meant and enforce it aggressively. That definition was protected. Challenges to it were difficult to win in court. Now, Those same definitions are open season. And within months of the Chevron ruling being finalized, legal challenges started piling up. Cases questioning how the fiduciary rule is enforced, cases questioning how the IRS interprets required minimum distributions, cases questioning what Social Security's own agency guidance actually means legally. And here's what's chilling about it. These aren't frivolous lawsuits. Courts are now required to look at them fresh, with no deference to the agency. That means the outcomes are genuinely uncertain in ways they never were before. Now, I want to be fair here, because this part is important. Not every expert agrees this is catastrophic. Some people, particularly on the deregulation side, actually celebrate this ruling. Their argument is that for too long, unelected bureaucrats in federal agencies had too much power. They say that putting the courts in charge of interpreting law is actually more democratic, more accountable. And honestly, there's a philosophical argument there worth understanding, even if you disagree with it. But here's what matters for you specifically, sitting at home, wondering what this means for your actual retirement account. Uncertainty costs money. When the rules around retirement protection are unclear, when the legal landscape is in flux, when employers and financial institutions don't know exactly what they're required to do, one of two things tends to happen. Either costs go up as institutions hedge against legal risk, or protections quietly shrink as the rules get challenged and rewritten. Neither of those things is good for the average retiree. Here's what a lot of people don't realize when they hear about Supreme Court cases. The immediate ruling is just the beginning. The real impact plays out over months and years as lower courts start applying the new standard to case after case after case. And in 2025 and into 2026, we started seeing exactly that. Retirement-related cases began flowing through the federal courts at a pace that retirement law experts described as unprecedented. Employers started challenging agency guidance on pension funding rules. Financial advisors started pushing back on fee disclosure requirements. Insurance companies started questioning annuity regulations that had been enforced under the old deference standard. Let me give you a concrete example of what this looks like in real life. Say you're 68 years old. You retired 5 years ago. You have a pension from your former employer. Let's call it a mid-size company, maybe a regional manufacturer. Under ERISA and decades of Department of Labor guidance, that company was required to fund your pension at a certain level, report its financial status to you annually, and meet specific obligations if the plan ran into trouble. Some of those requirements, specifically the ones around what adequately funded means, were defined by agency guidance, not directly by Congress. If a court now rules that a particular agency interpretation was invalid because it was based on Chevron deference that no longer exists, your employer might suddenly have far less obligation than you thought. And you might not find out until the day your monthly check is smaller than it should be. That is not a hypothetical designed to scare you. That is the actual legal terrain that retirement attorneys are navigating right now. So what does 2026 look like? Let's get practical, because that's why you're here. First, and this is the most important thing, if you have a defined benefit pension, meaning a pension where your employer promises you a specific monthly payment for life, you need to start paying attention to your plan's annual funding notice. Every pension plan covered by ERISA is required to send you this notice. It tells you the funded status of your plan. Basically, does your employer have enough money set aside to actually pay you what they promised? Before the Chevron ruling, the rules about what counted as enough were enforced with a pretty firm hand by the Department of Labor. Going forward, that firmness is less certain. Check that notice. Read it. If your plan shows a funded percentage below 80%, that's a yellow flag. Below 60% is a red flag. And if your employer is challenging any agency guidance in court, and some of them are, that's something you want to know about. Second, If you have a 401k or a 403b, pay attention to any changes in the investment options offered to you in 2026. One of the things that is most actively being litigated right now is the question of what investment options employers are required to offer and how they have to evaluate fees. If your plan suddenly removes certain low-cost index fund options, or if your plan fees increase without a clear explanation, don't just accept that quietly. You have the right to ask questions. You have the right to request a fee disclosure document. It's called a 408B2 disclosure, and your plan administrator is legally required to provide it. Third, and this one is for everyone, watch your Social Security statements. I know this might seem disconnected from what I just explained about Chevron, but here's the link. Social Security's own internal policies, the rules about how they calculate certain benefits, how they handle overpayment notices, how they treat certain types of income when calculating your benefit amount, a meaningful portion of those rules were developed and enforced under the same deference framework. With that framework gone, some of those rules are now being tested in court. If anything changes in your monthly Social Security payment in 2026, don't assume it's correct. Call the SSA directly and ask for a written explanation. Now, I want to take a second and talk about scams, because anytime there's a major legal change involving retirement money, the scammers come out of the woodwork. And I mean immediately. They follow the news cycle. They watch for confusion. And right now, if you're searching for information about your retirement and this Supreme Court ruling, you may start seeing things that look like official government notices, things that say your benefits have been affected and you need to call this number to protect your account, or things that offer to review your retirement plan for free in light of the recent court decision. Here's what I need you to understand. The Supreme Court ruling did not create any new government program. It did not create any new enrollment process. No legitimate government agency is going to call you and ask for your Social Security number or your bank account information because of this ruling. If you get a call, a text, or an email like that, hang up or delete it. Full stop. The only official source for information about your Social Security benefits is ssa.gov. The only official source for information about your pension or 401k protections is the Department of Labor's website, which is dol.gov. Everything else should be treated with extreme caution. Let me pull this all together for you, because I know that was a lot of information and I want to make sure you leave here with a clear picture. A 6-3 Supreme Court decision in 2024 eliminated a 40-year legal principle called Chevron deference. That single ruling opened the door to widespread legal challenges against the agency interpretations that protect your retirement savings, your pension, your 401k, your fiduciary protections, your Social Security guidance. Those challenges are actively working their way through courts right now in 2026. The outcomes are uncertain. Some protections may remain exactly as they were. Some may be weakened, some may be strengthened, depending on how individual courts rule. What you can control is this: stay informed, monitor your accounts and statements. Don't ignore annual notices from your pension plan, ask questions when something changes, and never share your personal financial information with anyone you didn't contact first through an official channel. This is one of those moments where the people who pay attention will be in a dramatically better position than the people who don't. And I know it feels overwhelming. I know retirement planning is already complicated enough without the Supreme Court flipping the legal table. But you're here. You watched this whole video. That already puts you ahead of most people. Don't leave money on the table. Don't leave protections on the table either. Stay informed. Check your accounts, review your statements, and please share this video with someone in your family who is retired or close to retirement. Because I promise you, most people have no idea this is happening, and they deserve to know.